And if you could just show for the record that all 7 commissioners are present. This meeting today is consideration and vote on draft amendments on Chapter 46, the Personnel Ordinance of the City Code. This is what we discussed, I think, most recently at the January 18th meeting, and I'll turn it over to the city manager.
Good morning. Mr. James McMacken is from the law firm of Morris James, has been the city's labor attorney and has assisted with this for probably 5 years now, and we have the last iteration of the changes to the personnel code that we're recommending. So I'll turn it over to Mr. McMacken.
Thank you, Ms. Lynn. Good morning, Mayor and Commissioners. I had discussed on January 18th the reasons behind these policy changes. They are primarily driven for the efficiency of workforce management at the city, compliance with the law. And what we tried to do was balance the give and take here. We wanted to make things more administratively efficient and effective. At the same time, we don't want to be punitive by any means on our workforce. And guiding that was the compensation study that you all received recently. As I said last time, what are the most important and salient provisions of these changes depends upon what seat you're sitting in. From my perspective, for the city, what's most important is cleaning up attendance and cleaning up attendance issues so that those attendance-based performance problems can be cured more efficiently. And also it streamlines determination procedures, yet remains consistent with due process as required by the Constitution. From the perspective of the employees, what's most likely to be most important to them is that they can accrue their vacation sooner. They can have access to some prorated vacation even in their first year of employment. And also the addition of 2 personal days to a leave bank, 2 paid leave days for them. So those, in my view, are the highlights. I am, of course, here to answer any questions that you all may have.
Thank you for coming today. I would like us to be mindful. I'm mindful that this was only presented January 18th. We received the draft document during that meeting, and then you went through it. So there was not a lot of discussion at that time. And so I've had time to look over it in the interim. I do want to note also that as far as I could see by looking online, this document has never been made public, available online, which I think is, for me, is a necessity when it comes to voting. I'll be bringing that up again. I do have some questions and things, and I'm going to try to be fairly quick, but one of the ways I've been looking at this, my perspective on this, is that our cities are the biggest asset we've got in the town, and that without our employees performing their duties competently, we're not a successful city, whether it's the business community that fails or the residential community. So I tend to and will be tending to tilt toward the employees. If Mr. Macklin, you mentioned some of the pluses in this, but there's also, in my opinion, some minuses. So I'm trying to look at those balances too, and I want to bring up some of them. One other thing on page 5. Now I'm using the version from January 18th, and at some point the page numbers are going to get us skewed by a page or so. I don't know why, but from what's turned out. But all my notes are in the original version of January 18th, dated January 10th. On page 5, I just want to make a quick note under 46-5 compensation. At least every 5 years, city manager's review of the pay plan shall include a comparison of compensation. I don't know how long that's been there, but as far as I know, Sharon's the first one to ever undertake that, and I wanted to compliment her on her because I think that's been a fantastic job. It's just a shame now seeing this in here that apparently we've never ever done that before. So we're behind on that. At the bottom of that same page 46.5-B, let's see, it mentions, no, I'm fine with that. If we would go to page 12, and this is 4610 under E, under termination, it gives reasons for being able to terminate a full or part-time employee. One of the reasons, it starts with incompetence, absences without job-protected leave, improper conduct, performance, neglect of duty, etc. Performance, to me, seems to be missing an adjective in front of it. What do we mean by performance? Good performance, we're going to get rid of them. Bad performance, it seems to me there needs to be a clarifier there. The other thing, and it's probably best to, if anybody has a retort, agreement, or disagreement, it's probably best to speak up right away. Not hearing anything, I'm going to go to the next thing at the
Well,
very...
Stan,
Yeah.
since you asked, performance issues are usually benign in the way they are noted for management purposes, so that management is in the position to determine how the performance actually is with an individual.
So you're saying we don't need an adjective?
I have never seen those adjectives used.
Okay, that's fine. The next thing, to Tony and others, is at the bottom of that page 12, it says, if a department manager or mayor concludes a full-time or part-time employee should be terminated, then they will be sent a notice of intent. How I am reading this is that now something new, the department manager can send a notice of termination to an employee. The mayor can send a notice of termination to an employee, but now the city manager cannot send a notice of termination to the employee because now the city manager is one of the judges. And so I disagree with that. I don't think the mayor should have anything to do with it. He's an elected official just as us. He's not an employer. And so I would disagree with that. And same thing with the department manager. They're not the employer. They would confer with the city manager, in my opinion, but not do further. This goes and removes the appeals process. And if you recall, before this, the Board of Commissioners acted as appeal. If the employee that was given the notice of termination followed a certain procedure, writing for requesting an appeal, the Board of Commissioners did that. I have been in on those appeals during my 11 and a half years here. I believe, I can't share a lot of what happened there, but I believe that everyone that requested appeal that I sat in front of, every employee had a comfort level of having that extra appeal process. And I would not be in favor of taking that away, nor was I in favor of taking it away, doing away with it when this was up before us in previous years, which might have been 2014 or something.
Mr. Mills, can I interject there?
You can.
This was, and like I said last time, the nice thing about being where I am as opposed to where you are is I don't make policy. I just take the policy as the city wants it to be and put it into legal terms and make sure that it's defensible. If the council wants to revert and keep things the way they are, that would be legal, of course. If they want to go the route that is designed in 4610, that would also be legal. And these were by design. So the reason the city manager is not sending out notices of intent to terminate, just for explanation, is to protect due process, because if she's the one sending it out and the one hearing the case, that would be, and it would impugn her independence. And if you want to retain the appeal, that is your right. But the way it's drafted right now is to make things more efficient, yet consistent with due process. So how you decide to go is up to you.
Well, and I would pass on efficiency in order to give the employee a second chance to hear an appeal by a group that is not their employer. And so I understand that if the city manager is the judge, then she would not be given the notice of intent. But again, I disagree with that whole process, so I would go back to the beginning. And that's just my flavor to this thing.
Dan, could I just underscore one thing to your point on that, and that is this goes against the city charter anyway, so I'm not sure how you're putting in place an ordinance that goes against Section 17E of the charter, which gives the commissioners the right to hear appeals, and the city manager has the sole authority to deal with personnel issues. So you're going to have to change the whole charter if you want to change this process. So it's not even a matter of if we change it here or not. You got to change the charter to change it here.
Okay, we'll look into that. Thank you.
Yeah. So you can't even do it unless you change charter. Thank you.
All intertwined in there also is we seem to have removed the standard of review, which gives me pause. Also on page 16C, there's the similar concept under 4613, progressive discipline, number C, criminal offenses. That also removes the appeal process. And I'm just going to say ditto to everything I've said before with respect to making an appeal process available. Page 25C, or 25. This is where the page numbers may start to be askew. This is under 4617D, personal days. All full-time employees shall receive 2 paid personal days. Again, I'm coming back to trying to analyze this with pluses and minuses, and I look at this as a plus for our employees. So, because I think that's all brand new. Is that right? Page 28 is, I guess, one of the more confusing things to me. Page 28, I'm looking specifically at 4619, vacation hours. A has the vacation schedule. One of the things that it does is accelerates vacation pay by a year. So that's in my plus column. I think that's a good thing. The next thing under that is something new. It says all department heads receive up to 160 hours per year, etc. So what this does to me is all department heads, that means any new ones or any, well, they're all current, regardless of their status, especially if they're under 9 years old, according to the chart above, immediately get accelerated to the equivalent of 10 years. And I'm not used to that type of program. In the school systems I know and the different businesses I know that the vacation pay is all the same. You certainly, a department head gets more pay. But Tony, you're shaking your head. That's what I know of the systems.
And I think the last time we talked about this, and correct me, Jim, if I'm wrong, this was an issue raised by the comp study.
That's correct.
Yes, that in order to draw personnel at that level, we needed to really take a look at what we're offering and how we're offering it and how quickly we're offering it. So when we looked at this originally, it sounded like in the interest of being able to attract higher the level and the competencies that we want, this was a smart way to go.
By referencing vacation pay, not just additional higher level of pay. Is that
correct?
Right? Okay. Well, I'm just not used to it.
And I would just add that discretion of the city manager. So an entry-level department head, such as the director of public works, who's been in the been used to, I'll say, vacation, or the city manager for that matter. That's what this is meant for, the discretion of the city manager. If there is a promotion from within and that individual, and we've had this, that individual only has, I'll say, 2 years of experience but is promoted, that is not always the case, that that individual will receive 160 days.
My next item is, I'm having a hard time comparing different parts of the code. On my page 29, which is 4619, still under vacation pay, but it's the bottom of that same A section that we're talking about. New employees receive 1 week per year of vacation from their start, prorated. So how I'm reading that, I'm trying to gain an understanding. How I read that is new employees receive up to 40 hours of vacation pay their first year prorated. However, in the chart at the beginning of A, I read it as employees from 0 to 4 years get 80 hours. I don't know if I'm reading that wrong. Should the chart, instead of saying 0 to 4, say 1 through 4?
Yes, please. Ms. Norton is the individual who deals with the payroll and also with the employees with their time.
Pull that microphone down to you. There you go.
If I say I'm short. The way this reads, yes, it's kind of convoluted. Best way to explain it is an employee accrues time from the day they start.
Right.
And then on the January 1st the next year is when they actually receive that time. And I'll say somebody is hired in June, which is easier to do the math. They come in June, so in June they start accruing. On January 1st, they don't get 2 weeks, they get 40. They don't get the 80, they get 40. Now, in the meantime, life happens. Say they have to take their child to the doctor, their dog to the vet. They've used up, when you say vacation, it's not necessarily vacation. It's hours used for personal time. They have to wait for the plumber. So now our 40 hours that we've accrued from June through January may be 20 hours. And that's all they get to use from January 1st until December 31st of the following year. Then in that full year, they're accruing their 80 hours, and basically they've worked a year and a half or maybe possibly 2 full years without very much vacation time. It's the way
that helps in part. So I'm very slow. I think you're fine. So for me, the chart that says 0 to 4 years, you get 80 hours at 3 months. Falls within 0 to 4 years. At 3 months, you get 80?
No. If you start on June, let's say we're going to hire somebody this June. They come in, so from July 1st until December 31st, they start accruing their 2020 vacation.
So during that time, can you take a day of personal leave or?
You can take it, but what happens is that comes off what you're accruing. So you're starting to accrue 40, but you may have to, like I said, life happens, take a day off, and these are hours. Somebody might have to leave at noon because the plumber's coming. Right. So now there's 4 hours out of that 40 that they don't get on January 1st. So now they're down to 36 hours. Their dog is sick. They have to stay home with their sick dog. There's 8 hours. So now they're down to even less. They're down to 32 minus the 4. So by the time these 6 months are over, some people chew into their vacation that they would receive on January, and then they receive nothing.
Okay.
What you're saying makes very good sense. It maybe just needs to be articulated.
It's poorly written.
In this section.
Yes.
So that it's clear, because what you're saying is not clear to me when I read.
No, and it's very confusing to a new employee because when they come in on their first day and during the onboarding process, I try to explain this to them and they look at me like, what? I have to work almost 2 years without a day off, and basically that's what I'm telling them. Yes. You don't get your vacation until you've been here almost a full year and have accrued it, and that's when you receive it. And it's only received on January 1st of every new year.
Well, I would say ditto to what Commissioner Burns said, just is it as clear as we can be, that's all. Thank you, Lois.
Thank you.
On page 47, my page 47, under 46-30 pensions, D, city contribution. There's a redundancy there. The black area at the top of that really should just be turned into a red line with the 4% changed to 6%, and then delete all that's in blue. This is 46-30 pensions, D, city contributions. It's just housekeeping. It was put in there twice, so to speak. Because we don't need a reference to effective January 1st. And then the rest of that is exactly as the original in black up above it, but for the change of the contribution from 4% to 6%.
Understood.
And on the social, you don't have to turn to it, but on the social media section, on and off over the many years, when things like this have come up, there's often been a debate on whether something should be codified 100% or whether you do a general codification and then you have a resolution with the policy in it so that it's easier to change the resolution and policy. And I would just throw that out for this at the same time, you know. That's all. Thank you.
I have three things real quick. One, I just have to agree with Commissioner Mills that, you know, there was no public posting of this document ever, and certainly prior to this meeting. I know I looked yesterday and it wasn't there, so I'm not sure, you know, I don't think we had the right due diligence and transparency into what we're doing here. You know, I think also I'm not quite sure how we can possibly vote on this today, given that there has not been a reconciliation of the changes here with the overall charter. So I think that we need to table this and make sure that there is consistency there. In terms of content itself, I do agree with everything Commissioner Mills said, and I had particular concerns with the section that takes away the right to appeal. And, you know, the charter is very clear that the city manager has the full authority to deal with, you know, personnel issues, and you're kind of taking away that authority and giving it unilaterally to the mayor, who actually doesn't have that unilateral authority in the charter either. So I ask you to look at that when you reconcile with the charter as well. In terms of the, you know, benefits for the employees, I'm fine with the content in general, with the exception of what Commissioner Mills said. But I do think we need to table any vote that's, you know, and fix the issues with the charter. Thank you.
It's my advice to the council, or to the commissioners and to the mayor, that the solicitor and I get together and work through the charter issue before any action is taken on this.
Thank you.
Yeah, and just to weigh in, and I certainly support, and I thank Commissioner Mills for so thoroughly going through the details in here and finding some of these items that do need to be corrected or changed. I think we would all agree that the appeal process is really critical, and we don't want to in any way deny employees that opportunity. And then certainly if it needs to be consistent with the charter, that's critical. I do have a question. Was the appeal process, as it's been altered, here, you said for efficiency. Was that the only reason, or was there some other intent? Has there been something else going on in the city that
The purpose,
that should come to light?
as I understood it, was so that in the event that we have a request for a hearing, so after the notice of intent to terminate is sent, if a timely request for a hearing is received, then on short notice, we need to get everyone together within the prescribed number of days under your hearing rules. And it slowed things down, yet was unrequired by due process. Now, given this charter issue, irrespective of due process, it's probably, if the understanding of the charter as announced today is correct, and I have every reason to believe that it is, revising your charter is a very complicated process that involves the state legislature. So we would probably just have to leave it as is without making these changes.
Okay. Thank you.
The only other thing I might recommend to Commissioner Sharp and the group is, that it may be worthwhile to have a meeting, a public meeting, the Personnel Committee to look at the next draft, and maybe, with the expertise of that committee, we could catch some of these things. I don't care either way, but it just might save, it may be an opportunity to, have the public see this and weigh in, as well as some of the experts on the Personnel Committee before it comes to the full board. But I totally defer to you. It's just a thought. So thank you.
I just have one question. And it's to the city manager, I think. With an inability to vote today, are we causing some administrative issues that I'm getting a head nod over here that I don't know if that's something you want to talk about now, but I think it's becoming critical.
It's becoming critical. It's causing a delay, but I think if we bring it back on March 15th and, just in 10 days, that would be timely.
Okay, that'd be great, because I just want to be very, very sensitive that what we're trying to do here is really on behalf of the employees. So
Correct. Yes.
Thank you.
Well, I want to articulate, I guess, what I've heard through Commissioner Schlosser and myself. I intimated earlier that I would not vote on it without this being in front of the public, so I just wanted to reiterate that. But what's going to be different March 15th? We have to edit this document to something that we're ready to vote on. We have to be presented something about the charter change at the same time. I can understand we need to get something done by March 15th, but again, for me to vote, we've got to get something out in front of the public early enough. It can't be that meeting or handed out at that meeting. So if we can work toward that goal, then I would be fine voting on it.
Think it's possible to do that?
Absolutely. I can, at least with these non-contentious issues, I can get you a revision, if not today, tomorrow, to be posted. For example, the immediate issues like giving the people 2 days of vacation, 2 days of personal time, giving them a quicker accrual with regard to their vacation, getting those issues out there for vote so that we don't have this backlog and all these other issues. The non-contentious things, I can get you very soon. And I can get you everything else very soon as well, but that still requires debate from what I understand within the Personnel Committee. But the things that I'm not sensing require debate, I can get a draft to you to review and then discuss and provide to the public, and then eventually you can vote on it if you wish. I could do that today or tomorrow, sure.
I think,
Go ahead. No, go ahead.
I think the most ideal thing would be to have it 7 days in advance of our meeting. That's when our agenda goes out. If you can do it within that time frame, I think that would be reasonable.
Absolutely.
I guess I want to know, how are you interpreting what's set up there? How many of us have said we don't like the appeal process? So what does that mean? Does that mean you take it out and revert it back, or do you leave it in and then we vote on it by component or something?
Well, your charter issue, for example, is going to require some conversations and research between the solicitor and myself. So that issue, I understand, given the debate on it, people are not comfortable with it. But the simpler things that the city needs in order to run, like the 2 additional paid personal days, we can do that chunk of the revisions and have it ready for your discussion. And we can have that ready for your discussion and deliberation sooner. And the other things that may require additional contemplation and potential revision by the Personnel Committee, in my view, those would have to wait for a date subsequent to March 15th.
And we would just revert back to the standard language that was already here about the appeal process.
In the meantime, correct?
In the meantime.
Turn it into a 2-step
Yes,
process.
yes.
That'd be fine. And I agree with Commissioner Calusi's desire to have it in front far enough in advance. Thank you.
You're welcome.
Anything else? All right, with that, I guess we'll just move forward and set it up for the 15th and have something at least ready to go on the 15th to talk about. You guys will talk about the charter change.
Thank you for
Thank you,
driving.
Jim.
Thank you for driving down through the snow.
Happy to.
With that, this meeting is adjourned.